Hello, and welcome to Lawful Insight. My name is Trisha Morales Padilla, and I'm an attorney here in San Antonio, Texas. And this podcast is meant to bring you bite-sized pieces of information to help make the road for your divorce or your custody suit a little less bumpy. If you have any questions, you can check us out on the web at moralespadillaLaw.com. Call us at 210-410-8013, or you can email us at lawfulinsightpodcast@gmail.com. Today I want to talk a little bit about Child Protective Services, or also known as CPS, and a little bit about their process that they go through. Now, CPS normally works as a referral comes in to their intake division, and it's a referral for some type of neglect or physical abuse. They then launch an investigation, and that could entail several different things just depending on your specific situation. And their investigation could generally take anywhere from about 45 to 65 days, again, generally depending on the situation. From there, they either close out the investigation, making some type of a finding, or they might decide that it needs to go into what is called family-based services. Now, family-based services means that you could still have your children or child placed with you, but you either have what's called a safety plan, which is a set of services that they want you to complete to try and address any concerns that they have based on the investigation and the referral. Or they may also have a supervisor, so somebody kind of checking in on you, a family member, a friend, a neighbor checking in on you with your children. Or they may have you voluntarily place your child with a relative or with a neighbor while you address these concerns. From there, if they feel that the concerns are not addressed, or you're not being cooperative, or you haven't completed things, or there's still issues coming up, then they may make the case legal. And what that means is they will file with the court to remove the children from the home, and they will file a petition for termination. Now, what that means is once the children are removed, they've got 14 days to have an initial adversary hearing for the judge to determine if the removal will stand and if they will give you time to work services. If the removal stands and the department is named temporary managing conservator, at that time you are not terminated and you don't lose your rights, but you will have to work services and your rights are severely limited. You will get some type of a supervised visitation, and you will have quite a bit of services that you will need to comply with through your CPS case, and you will also be appointed an attorney. Now, I know on the last podcast, we kind of talked about how CPS affects an ongoing divorce or a custody suit. And so basically, if you have one in the process, it puts it on hold. If you're in the middle of CPS and you want to now do a divorce or do a custody suit, you'll have to wrap up the issues with CPS normally, especially if you're involved in a legal case. Those will have to get resolved with CPS, and that court case will have to resolve itself before you can proceed or finalize any type of a divorce or a custody suit. And again, these are all fact specific. Everybody's specific case and information and circumstances kind of change things a little bit. So if you have any questions, you can give us a call at 210-410-8013, or you can check us out on the web at moralespadillaLaw.com. Again, thank you for listening. If you're listening to this on Podbean, go ahead and subscribe and hit the like button. And if you're watching this on YouTube, go ahead and hit like and subscribe to the channel. Thank you.